Good evening and welcome everyone to our firing line debate with the William F. Buckley Jr. program. I will begin by introducing the Buckley program, our mission statement, and then say a few words about our two wonderful guests. So the mission of the William F. Buckley Jr. program is to promote intellectual diversity at Yale University. We aim to expand political discourse on campus and expose students to often unvoiced views. We believe that ideas have consequences and that genuine intellectual diversity is essential for advancing critical inquiry and avoiding ideological complacency. Our hope is that by providing a home for a diverse collection of serious conservative thought, we can provide a forum for Yale students to consider and examine a range of political philosophies to which they are rarely exposed. As such, the purpose of this program is to foster open political discussion and intellectual engagement on campus. Now, with respect to the debate that we have today on term limits for the Supreme Court, I have had the pleasure of studying under both of these two fine legal titans. And to say a few words about Professor Amar, Akhil Amar is a sterling professor of law and political science at Yale University. He teaches constitutional law at both Yale College and Yale Law School. He started his career in 1980, graduating from Yale Law School in 84, and clerking for later Justice Stephen Breyer. Amar joined the Yale faculty in 1985 at the age of 26, and he is Yale's only currently active professor to have won the university's unofficial Triple Crown: the Sterling Chair for Scholarship, the Devon Medal for Teaching, and the Lamar Award for Alumni Service. His work has won awards from the American Bar Association, the Federal Society, and he has been cited by Supreme Court justices across the spectrum in over 45 cases. He tops scholars under the age of 65. He regularly testifies before Congress at the invitation of both parties, and in surveys of judicial citations and/or scholarly citations, he typically ranks among America's 5 most cited mid-career legal scholars. He has recently launched a weekly podcast aptly named America's Constitution, a wide assortment of his articles and op-eds and video links to many of his public lectures and free online courses may be found at akhilamar.com. Adam White is a senior fellow at the American Enterprise Institute, where he focuses on American constitutionalism, the Supreme Court, and the administrative state. Concurrently, he co-directs the C. Boyd and Gray Center for the Study of the Administrative State at the Antonin Scalia Law School at George Mason University. Mr. White previously practiced constitutional and administrative law, particularly in the regulation of energy and the environment, finance, and telecommunications. He was a research fellow for Stanford University's Hoover Institution and an adjunct fellow for the Manhattan Institute. He started his legal career as a law clerk for Judge David B. Sentel at the U.S. Court of Appeals for the D.C. Circuit. Mr. White has testified before a variety of U.S. House and U.S. Senate committees, including the Senate Judiciary Committee, the House Judiciary Committee on Subcommittee on Regulatory Reform, Commercial and Antitrust Law, the Senate Commerce Committee, and the House Financial Services Subcommittee on Oversight and Investigations. In 2017, he was appointed to serve on the Administrative Conference of the United States, and he was also recently appointed by Joe Biden to serve on the Supreme Court Commission, the Commission on the Supreme Court of the United States. He also serves on the boards of 2 nonprofit organizations, Speech First and the Land Conservation Assistance Network. As you can see, these 2 gentlemen are very qualified, so I will soon be segueing it over to opening remarks from Professor Amar.
Well, it's a great pleasure to welcome my friend Adam to Yale, and we're going to talk about term limits. I guess I go first, so I'm going to tell you my proposal. In a bipartisan op-ed published in the Washington Post in 2002, Stephen Calabrese, the co-founder and co-chair of the Federalist Society, who does not always speak for the Federalist Society, however, and I floated the idea, here's the idea, that each justice should do 18 years of full and active service on the court and should thereafter have a different portfolio of judicial responsibilities. So they'd still be a justice, but they'd transition into other kinds of senior service that would involve less active participation in deciding cases on the merits. The bipartisan authorship of this 2002 op-ed was purposeful. The 18-year idea was then, and remains today, neither left nor right, neither blue nor red. Now, in a more recent development, on April 28th, 2021 episode of my weekly podcast with my friend Dr. Andrew Lipka, Yale class of '78, who is hiding back there in the back row. America's Constitution. I listed 18 distinct reasons supporting my particular version of the idea of 18 years of active service, followed by a lifetime of relaxed senior court service. The podcast is free. It's weekly, so you're most welcome to listen to the episode in full. It's actually the first of 3 episodes, but that one's called 18 Arguments for 18 Years. And here in brief are the 18 arguments. 1. The status quo of lifetime active service, when combined with a partisan arms race, encourages each of our 2 major political parties to appoint unduly young and unseasoned jurists to the court in the hopes of entrenching the party vision on the court for as many years as possible. 2. At the other end of the life cycle, the status quo allows full service of justices who are too old, whose arteries have literally hardened, and who are not at their prime. Historically, most justices have not done their best work in their superannuated years. 3. The current system creates the possibility of too long a time lag between initial appointment and current judgment. The most senior active justices may be wildly out of touch with the nation's evolving mood, because these justices were appointed long ago, even if they're still relatively young and spry and their arteries have not yet hardened. This time lag is particularly problematic for younger Americans, that would be you all, who were not even voters when many of the current justices were selected. Many of America's younger generation lack a close emotional connection to the court, in part perhaps because of the long time lag. The reform statute caps this time lag at 18 years for the court's most important function, decision-making in en banc cases, when the justices sit as a group of 9 and decide cases on the merits. 4. The current system enables justices to strategically and politically time their resignations. This is a less attractive model of judicial independence. Currently, some justices act politically when they time their exits. 5. 18 is a magic number, enabling regular and steady replacement a la the Senate. The Senate staggered replenishment system adds a new 3rd every 2 years. The 18-year active service plan adds a new 9th every 2 years. 6. 18 is a magic number in a second and distinct way. Appointment power is regularized and smoothed out across presidencies and across quadrennial presidential elections. Each president can count on 2 appointments, and this smoothing makes replenishment less arbitrary, random, and capricious. 7. Relatedly, regular replenishment of the front bench makes it easier for voters to think about the court's future every presidential election without awkward and indeed ghoulish speculation about the life expectancies and health prognoses of individual sitting justices. We know who's going to rotate off. We don't have to speculate about her cancer or his private life or any of that stuff. 8. Shortened terms of active service will reduce the stakes and the temperature of currently overheated court confirmation battles. 9. Shortened terms of active service will increase judicial humility. 10. Replenishment every odd year regularizes appointments within each presidential term, with half the active justices chosen pre-midterm, year 1, and half chosen post-midterm, year 3. The opening up of vacancies in odd years further reduces the political temperature of court confirmation battles by staging these battles in non-election years, 2 and 4. 11. An 18-year cap on active service brings the U.S. Supreme Court model into closer alignment with the most admirable state Supreme Court systems, almost none of which feature as active service for life. The federal government can and should learn from lessons of states, the proverbial laboratories of American democratic experimentation. That's a point associated with Louis Brandeis most prominently, states as laboratories of experimentation. 12. Ditto on the comparative international front. Almost no other modern democracy in the world has a lifetime model of active service for its apex court. America as a whole can learn from the experiences of the world's other notable democracies. 13. Unlike current reform proposals to pack the court, the 18-year proposal is not partisan and is unlikely to spiral out of control when when party control shifts in Washington, D.C. at some point in the future. Now, on reflection, that podcast point was a bit of a cheat. It did not identify an improvement on the status quo, but merely an advantage over another widely discussed approach to court reform. But here is a true improvement, because I like the number 18, so I need to substitute, which the podcast didn't count as a separate virtue. The 18-year proposal minimizes the likelihood of a short-staffed, evenly divided court. Whenever any one of the active 9 justices is unavailable, a senior justice can easily pinch hit. 14. The 18-year proposal not only eliminates the occasional or regular reality of politically timed retirements, it eliminates the public perception of politics in judicial retirements, a perception that may wrongly exist when Justice X in fact retires nowadays for entirely personal reasons, but a perception that adds to the current public cynicism about the court. 15. Under the 18-year plan, every active justice is slated to serve as Chief Justice in his or her last 2 years of active service. So you're 16 years an associate, last 2 you're chief. This too evens out power across presidents and eliminates the current lumpiness, giving some presidents, for purely accidental reasons, more power than others to pick the court's chief. 16. Rotation of the Chief Justiceship equalizes power within the court. Relatedly, associate justices will not have incentives to pander to the president in the hopes of one day being nominated, by the president of course, to become Chief Justice. Everyone will get a turn, you see. Even if associate justices never in fact pander to the president, the mere public perception that some justices may well be auditioning to be chief is undesirable. 17. Chief justices will be those who clearly understand the court, having typically served on the active bench for the previous 16 years and having received, one would expect, special training by their predecessor Chief Justice when they're approaching their own last 2 years of service. Finally, 18, circuit duty of these senior justices. So once you rotate off, actually you do other things, including writing circuit, could help reconnect the Supreme Court with lawyers and judges in the hinterlands. A nice echo of the original vision of the court as implemented by the Judiciary Act of 1789. So that's the basic idea. I've thrown at my friend Adam and you all just a lot of food for thought, and I'm looking forward to hearing Adam's reactions.
Thank you very much. That was great. I'll just say I was thinking about, as the introductions are being read, it reminded me of a quote from William F. Buckley, of all people. He once said that it's harder to imagine a more anticlimactic statement than "for God, for country, and for Yale." And I'd say actually hearing my bio after my friend's accomplishments is even more anticlimactic. So it is a real honor to be here with Professor Amar, with Akhil, and also a real pleasure to be back here with the Buckley program. Last year, I had the honor of leading a series of discussions on Republican virtue and the Constitution. And it was a pleasure to get to meet some of the students then online. And frankly, a lot of my views of the subject tonight are informed by similar themes. They're also informed, as was mentioned during my introduction, by my service on President Biden's Commission on the Supreme Court, a great 36-person group project. And frankly, when I began my service on the commission, my instincts were inclined towards the arguments and the conclusion that Professor Amar and Professor Calabresi make. By the end of the commission's work, I had basically talked myself out of it. It calls to mind a quote from another famous Yale figure, William O. Douglas, who once told Felix Frankfurter, after the end of one of Frankfurter's famous lectures, I arrived here ready to agree with you, but you talked me out of it. Not you personally, but my experience on the Supreme Court Commission. I was inclined towards Akhil's point originally, because he's right that there are real problems. There are real problems that term limits are intended to solve. And he's mentioned a couple of them. I disagree with a number of the things that he cited, but a couple of them are exactly right. Life tenure is longer than ever before, surely longer than the founding generation ever expected. A justice on the Supreme Court now is expected probably to serve for 20 years or more. Of course, there were long-tenured justices in the founding era, but not nearly sort of the trends that we see today. And second, and as Akhil is exactly right, that we do get the sort of ghoulish death watch at the end of every justice's tenure, and I think it's a very ugly feature of our politics. And I think perhaps even the bigger problem is the problem of timed retirements. The fact that each justice, pretty clearly now, if he or she is going to retire on their own schedule, it tends to align with the political circumstances of a justice retiring alongside a president of his or her nominal political party. In fact, I think it's a real problem that we see the first time we see a justice and the last time we see a justice is standing next to a political president who seems to be aligned with that justice, who's appointing that justice or who that justice chose to appoint his or her successor. I think it's deeply troubling, and that needs to change. But I'm still against the term limits. And as Akhil mentions in his testimony to the commission and elsewhere, term limits might be a misnomer because, as he points out, the justices under his approach would actually continue to serve on the court, albeit in a different capacity. So 18 years as I can't remember the term you used, but can I say an active justice? Is that fair? Before moving on to senior status.
Right.
But frankly, I think that the term limits frameworks that I've seen proposed would actually exacerbate many of the problems that I worry about. And here's why. My first problem with the idea of Supreme Court term limits is just fundamentally a constitutional problem. Under our existing Constitution, I don't think you can interpret the terms of the constitutional terms, the justice holding his office during good behavior. I don't think you can read that in a way that allows for a material change in particular justices' duties over time. I think the founding generation expected the justices to serve and to serve in full for life. It's true that the Congress can specify particular duties, including circuit riding, and I wish they would bring that back. It would be good for the justices to eat some of their own cooking from time to time. But I don't know that we can draw distinctions among the justices in the way that my friend suggests. Of course, a constitutional amendment would solve that problem. But I still would be against it. I think it's very dangerous to have a system of justices in which they're thinking possibly about their next job, right? I mean, 18 years is still a pretty long term, but I don't exactly like the idea of justices thinking about what they might do at the end of 18 years. In this day and age, a justice appointed even at the age of 50 or 55 could have a pretty lucrative career after serving on the Supreme Court. The framers, and this comes up in Federalist 78, Hamilton writes that it's important that we need life tenure precisely to attract the right kind of judges, namely the judges who would entirely give up their legal practices forever for the sake of dedicating themselves to the public service and really vocation of being a judge or a justice. I think that's important, and I don't think we really know what it would look like if we had justices roaming the country doing other jobs. I think it would probably increase the incentives for justices becoming celebrities, which is another bad aspect of modern politics. And frankly, once you create a market for former justices, maybe some big lucrative law firm or a mediation firm or something, you'll have sitting justices thinking, well, wait a second, if I leave now, I could be making $18 million a year at the such and such law firm. I think once we open that set of incentives, it would really distort how the justices see themselves and their careers. And I'm against anything that makes them think of their office less as a vocation and more as a job. But that's not even the main reason why I'm against Supreme Court term limits. I don't think the debate about Supreme Court term limits is really about the court. I think it's about presidents and the Senate. We've arrived at a point where we meaning politically engaged DC lawyers, I guess, we've come to expect that Supreme Court appointments come with the presidential election. Right? Think about how much Supreme Court appointments, the Supreme Court itself, has become a really core feature of our presidential debates. We've come to, again, identify the presidency with the Supreme Court and thinking of Supreme Court vacancies and Supreme Court appointments as property of the court. And I think Akhil really pointed out in one of his 18 reasons that one of the real features for advocates of term limits is that it would map on easily to the 4-year presidential cycle. 2 vacancies and most likely 2 appointments during every presidential term. I joked during one of our Supreme Court Commission hearings that we would be treating seats on the Supreme Court like couches in the Oval Office. You deliver 2 new ones after every presidential inauguration. I think one of the greatest problems in our one of the greatest constitutional problems of our time is the expansion of the presidency in our politics and the departure of Congress. The weight of the presidency and the vacuum of Congress. And so I'm instinctually against anything that would decrease the power of Congress relative to the president. And while, to be fair, Akhil's proposals don't touch on this, most of the other proposals for term limits, they grapple squarely with the problem of Senate power in a system of term limits. Because if the idea is for each president to get to appoint 2 justices per presidential term, then you have to find a way to prevent the Senate from preventing appointments. The Supreme Court Commission's report grappled with this over a few pages. One of the legislative bills right now that's pending, one by Representative Rokana in the House of Representatives, their bill explicitly states that if the Senate does not confirm the Supreme Court nominee within 120 days, or does not act on the, I think they said, does not exercise their advice and consent power within 120 days, it will be deemed waived. There really is no way to make the regular calendar of judicial appointments work unless you take power away from the Senate to block appointments or to not act on them at all. That's something I've been writing about throughout my legal career, from beginning when I was a law student at a lesser law school down by Boston, writing about the importance of the Senate's, no offense to my friends who are watching live, on the importance of the Senate to have full power and discretion to act or not act on any judicial nomination. I've been saying that since 2004, and I still say it now. But the bottom line is, yes, I want more Senate, not less. But I'm left, it is a dissatisfying answer, because at the end of the day, the problem remains. We identify the court politically with presidents. One of the greatest problems that needs to be solved is that we need justices to stop timing their retirements. But I don't think there's a way we can do this through law without making the problem worse for the reason I just explained. So ultimately, I mentioned Republican virtue at the beginning of my remarks. That's basically where I end on this. I think right now, one of the best things that the leading legal minds of our time, like Professor Amar, like Professor McConnell at Stanford and others, the best thing that they could do, along with other opinion leaders, thought leaders, and judges, is to really push back culturally on this trend of judges timing their retirements. Not only when the other party's judges do it, but when our own party's judges do it. But I think that is what the situation, what the time calls for. So again, thank you so much for inviting me to talk about this. And I have lots of other criticisms of his ideas, but we'll save that for maybe the next segment.
Yeah, well, thank you both for that. Now we'll segue into about 2 minutes of rebuttal. So we can start with you, Professor Amar.
So he mentioned he has some constitutional objections, but he didn't quite articulate them. If your life depended on it and you had to bet on the constitutional issue, I would say you could bet on me with pretty safely on that. So it's constitutional, but he says, gee, in the end, even if there's a constitutional amendment, he'd be against it. But he didn't give the reasons why. It's pretty clearly constitutional, I think. But let me bracket that. I think he made 2 big points. One, he's worried about what you might do after 18 years. Maybe you try to make a lot of money. I think that's a real concern in my newest incarnation of the plan. I would actually have the current justices create a ethics, constitute themselves as an ethics board, and they would issue a ruling, might be non-binding, about whether anyone's post-court service is proper or not. And maybe you could still do it, but it's going to look pretty bad. And who's going to want to hire you if the existing justices say, no, 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 this is a bad thing to do? And you're going to, in your confirmation hearing itself, ask, would you even, are you willing to, in advance, behind the veil of ignorance, abide by that? And by the way, in American history, oh my gosh, how many people have left the court for political things? Mm-hmm. Almost everyone in the early period. So John Jay leaves the Chief Justice position to be governor of New York, and Cushing is running for the governorship of New York. And Salmon P. Chase desperately wants to be President of the United States, even as he's Chief Justice of the United as he's Chief Justice. And Charles Evans Hughes leaves the courts to run for the presidency. He comes close to winning and loses California by 30,000 votes. Bill Douglas wanted to be vice president. So that actually has been a problem in the existing system. But I think mine actually improves that by saying, whatever you want to do afterwards, there's going to be the existing justices actually rendering a kind of, it could be an advisory ruling on whether this is sort of proper or not. Now, as to the gridlock issue, well, presidents are going to appoint. I just respectfully disagree with the game theoretic analysis that when there's divided government, there's going to be gridlock. I promise you that, that there's a price for everything. Mitch McConnell says, oh, we're not going to consider anyone that Barack Obama proposed in the 7th year. Barack Obama says, actually, I was thinking about nominating Amy Coney Barrett. Mitch McConnell would say, deal, right there. Okay, and if anyone disagrees, you know, I'd like to make bets with you about things, okay? Because that's absurd. Now, the only question is where the deal is cut. This is about the balance of power versus the president and the Senate. You know, is it 3 days before the end of a president's term, or 3 months, or 3 years? Who is likely to win the upcoming election? All of those things. So I don't think actually that's the problem to be solved. Politics actually solves the problem. Ronald Reagan, he wanted Robert Bork of this faculty, didn't get Bork. Then he wanted D.H. Ginsburg, didn't get Ginsburg. He got Kennedy. There's a price for everything. You keep proposing people. If the Senate of the opposite party says no, you'll be able to find someone. If you're willing to compromise, and if you're not, the seat stays vacant, and it's a short-staffed court, and I help solve that problem by allowing senior justices to come in and pinch hit when there's a short-staffed court. So we actually always have 9 to decide every issue before the court.
That last point gets to what I wanted to make the core of my rebuttal, the idea of what the court would be like with a set of senior justices at the ready to serve, well, first of all, to serve mostly not in their traditional duties, but then when a court is short-staffed, to come into the court. Setting aside my constitutional doubts, and he is right that if you're going to bet on constitutional interpretation, read his books and bet on what he says. This is one where I do disagree. But setting aside the constitutional point, practically, I think we should think through what it would be like to have effectively a set of shadow justices waiting in the wings. I think that in itself would change Senate politics. If you know who's on deck to serve to come from a senior justice to be the current justice, that creates an entirely different calculus. Mm-hmm. But even more than that, and one of the reasons why I'm against drawing lines among the current justices is in my time on the commission and reading about it since then, I always see the distinctions in terms of the active justices who then go on to be senior justices. But logically, if we can draw lines among the justices based on their service on the court, why couldn't a future Congress and president pass a law just changing it? I could see arguments why the junior justices might need a warm-up period, right, to serve on the court in a lesser capacity until they really understand how the court works. And only once they've ripened on the court should they have the full suite of powers of a justice. And I think that once we open the door to drawing lines between different classes of justices, we'll create a system in which we'll constantly debate whether the next Congress is going to redraw the lines and move, say President Biden gets to appoint another justice this term. If we're living in the world of senior and junior justices, could you imagine a future Republican president in Congress passing a law that says, actually, we want the junior justices, who just happen to be Justice Jackson and Justice Amar, they should spend a little bit more time really acclimating themselves. And we're going to bring Justice Thomas and Justice Alito back on active service. I just think it's very dangerous once we start drawing those lines. Again, it's understandable. On the circuit courts, judges are allowed to voluntarily accept senior status. They're not really forced into it, but they can elect it. And a lot of judges have done great service. Some Supreme Court justices, they hear cases, right? Justice Souter is hearing cases in the First Circuit. Maybe Justice Kennedy is now hearing cases in the Ninth, I can't remember. So we've had things like this. But I think the difference is in what we're now talking about in terms of senior and junior justices along the lines of mapping onto this term limit system would open up an entirely new Pandora's box. And as a conservative, I'm just instinctually against Pandora's boxes or even opening them.
So
we're going to transition into questions now, if that's all right. And you can take jabs at each other during the question period as well. Yeah. I'm excited for that. So we'll start with moderator questions, and then we'll transition into audience questions. So the audience should start to think of their own for now. Mm-hmm. So first question, Both of you kind of shied away from the constitutional dispute as to whether or not term limits are constitutional in the first place. I'm interested in like prodding that a little bit further. The gut reaction when many conservatives first hear about term limits, if it's not advocated by Professor Amar, is that it's unconstitutional. They constantly call to Alexander Hamilton's writings. So why exactly do you, Mr. White, think that it's unconstitutional, and I'd like to hear Professor Amar's response to that.
Well, thank you. And it's true, I've been sort of sidestepping the issue. The Constitution speaks only in the term of the judicial office, the word office. And I understand that the word office is susceptible to many meanings, and you could see as an original matter the founders using the term office and legislating a framework in which the judicial office meant what's being proposed now, not serving in the same function the entire time, but rather sort of different stages of judicial duty. And he's much better versed in the founding era debates and as we see in his books. But in my study of the founding era, in the Federal Constitutional Convention and the ratification debates, I didn't see much debate around whether the judicial office would be susceptible to that. In fact, the critics of the Supreme Court power, most famously the anti-federalist Brutus, his whole criticism of the federal judiciary was premised upon the view that these judges would have immense power, life tenure, that would not be susceptible to congressional control over time. And I think the fact that we've never experimented with this at the federal level, we have had, again, as he pointed out in his commission testimony, Congress has put duties on the justices, most importantly circuit riding, which I think, again, we should bring back. But it was never there were never distinctions drawn among the justices with different kinds of duties other than the Chief Justice, whose office is specified by name in the Constitution. I think the fact that we've had an unbroken history at the federal level of this notion of a justice and what their office entails, if it wasn't consciously accepted in the founding era, surely that meaning has been liquidated in the Madisonian sense, or at the very least, after 200 more years of this, I'm wary of experimentation.
So you're right that I think it's pretty simple. You're a justice for life. You get paid for life. You have your title of justice for life. You've left the academy. I'm here, and let me tell you, I think a lot about life tenure. I recommend it to all, and here's what it means. I'm a professor, and I have that title, and we professors care about titles, and so do judges. Oh, and you got to pay me, and I kind of care about that too. Now, you can tell me over the course of a lifespan, I'm going to do different things at different times. A sort of phase service, but from a formal point of view, you're a justice for life, you get paid for life, you have the title for life, you have different duties. At the founding, the idea was 1 month a year, every justice is in DC or the national capital, 11 months a year, you're riding circuit. It's very similar, except I'm just jiggering the numbers. Now it's your first 18 years, you're in the national capital, and after that, you're riding circuit. But that's the same rule for every justice from day one, and you know this even before you are sworn in. You're kind of agreeing to it. You're, in effect, if you want to think about it, you're agreeing to step down in a certain way on day one, 18 years hence, just like Steve Breyer says, I'm going to step down, as soon as my successor is confirmed or at the end of the term. So I don't think actually there are too many constitutional problems with this phased service idea. I also think that when he says, well, he reminds me, this is the knock on Yale law professors. They say stuff like, well, that works, in practice, but does it work in theory? See, because all the states have, except for Rhode Island, they've got term limits. Yeah. And it works pretty well in a lot of the states. No country in the world has a life tenure model. And they managed to solve some of these theoretical problems that haunt my friend Adam's a fevered imagination about what are you going to do after 18 years. We managed to do it state after state after state, country after country after country. I want to say one other thing since I'm teasing, and we really are friends.
We are.
I love Adam because he's very fair. He really is, and very thoughtful. And the fact that he's on the other side actually gives me genuine pause.
A brief pause.
No, genuine pause. Yeah, at the end of the day, we still might end up on different sides of this thing. And I'll tell you, see, I don't say, this thing about Adam Lightly. So there's another person. This is being recorded, but I don't hold this other person in especially high regard. Happens to be a Yale Law School graduate. His name is Ro Khanna. He's a congressperson, and his bill is kooky, and it's unconstitutional. And the idea that by a mere statute, and with the Senate's really going to go for this.
Yeah, the Senate version of the bill does not have that provision, by the way.
Of course it wouldn't, because, how can they, be denied their ability to say no? Because he says if you don't confirm in some time period,
120 days.
The guy's deemed, or the person is deemed confirmed. How does that? Have you read the Constitution, Ro? You can't do that. The Senate is allowed to just say no. They've got a gazillion ways of just saying no. That's what they're designed to do, is to say no. The Senate takes saying no to a high art form. Okay? It's like the Paul Simon song, 50 Ways to Leave Your Lover. They have 50 different ways of saying no. They get to say no. They get to blockade. We're not going to give you a hearing. We're going to give you a hearing, but we're going to slow walk it. We're going to get a hearing, but you don't get a committee vote. You're going to get a committee vote, but you don't get to the floor. Oh my goodness, too much time. Oh, so, too bad, so sad. So, and when Ro kind of has these ideas, that doesn't give me pause. I'm being straight with you. The fact that he actually has a lot of anxieties, that should give us all pause. But at the end of the day, we got to decide whether this is a net improvement. This would bring the federal model more into line with what most states do and what most countries do.
I'll give you 30 seconds to respond.
Yeah. I think that our Supreme Court, I would not change our Supreme Court to look like state Supreme Courts. I come from the state of Iowa, where they have a very different system of recalls and elections and so on.
Yeah. I don't like that. You're right.
Maybe it works at the maybe it works at the state level where the stakes are lower. Yeah. I think for our federal issues and for the stakes of the Supreme Court, what we had from the start's the best.
Now on stakes.
Well, we should probably. Sorry, Professor Marble.
Next time I'll let you have the last word. I keep.
No. I went on for too long.
I'll ask one last question, and then we're going to pivot over to the audience, so people should get ready. One of the points that has been mentioned about the court in history, and not as often today, is this kind of image of it as being aristocratic. It has this kind of aesthetic significance. They wear these like old robes. They all look very august and impressive and kind of intimidating. I'm curious how the public perception.
So you read their opinions.
Well put. But I wonder how the image of the court would change if there were to be term limits. Routinely, the Supreme Court has higher approval ratings than the president and Congress. I wonder if this could boost Supreme Court's perceptions with the Supreme Court's perception with the public, or kind of detract by bringing them down to the level of the common man. And we can start with you, Professor Amar.
So it's a perfect segue on stakes. I do think we take these extraordinary public servants and we put them through the ringer in the confirmation process. And it's ugly. Wasn't very nice for Robert Bork. It wasn't very nice for my friend Clarence Thomas. It wasn't very nice for my friend Brett Kavanaugh. And part of the reason that I think we put these folks through the ringer, and it's an ugly process, is that it is for life. I'm actually trying to lower the stakes at the very beginning so that it's going to be easier for us to actually have respect for these folks who are very dedicated public servants. Look, most of them, I got to be straight with you, they're very distinguished Court of Appeals judges, almost all of them before they are appointed. 8 of the 9 were sitting federal Court of Appeals judges of high distinction before reaching the Supreme Court. The only one who wasn't was Elena Kagan, who was dean of some obscure law school up in Cambridge, and then Solicitor General of the United States, which is a very judicialized position. These are folks, they graduate, they went to impressive schools. And then they went to impressive law schools, and they graduated at the top of their class. They did very fancy clerkships, and they could actually have made $1 gazillion in practice. And their spouses reminded them of this regularly. And they chose instead to toil away in relatively obscure lower court positions for less money than professors make in law schools, professors who don't do anything. And you could say, well, they're doing it so they could get appointed by the Supreme Court. The odds are so low that lightning will strike. So they're just, I really admire them, honestly. They're really distinguished people, and I respect their service. And then what's the first thing that we do once they get nominated? We beat them up, but good. And I think I'm trying to actually solve that problem a little bit in two ways. It's only for 18 years, it's not for 35, so we don't have to fight quite so fiercely. And we're going to have these contests in years 1 and 3, which are the cooler years in our political cycle than years 2 and 4. And maybe I failed in that, but that's actually what I'm trying to do, so that we actually can, treat these folks with actually the respect that they deserve.
On the point about judicial careers, Mrs. Scalia once said, this was quoted after Justice Scalia passed away, she said, "My husband worked harder and harder for jobs that paid less and less." So I guess she knew firsthand.
Yeah.
One thing that Justice Scalia said that was correct in his dissent in Planned Parenthood versus Casey is that Supreme Court confirmations are politically ugly because the court has grown ever more politically consequential.
Mm-hmm.
I think that even with the proposal that Akhil has, I don't think you can take the political stakes out of the confirmation process. And frankly, an 18-year term is long enough that I think that they would still be as politically controversial. Maybe if each one served a 9-year term, that would seem shorter, there'd be rotation every year. 18 years is still a pretty long time on the court. And so I don't think that the individual nominations would become less controversial. And frankly, familiarity tends to breed contempt. And I think that having even more familiarity with the Supreme Court confirmation process would create more contempt among senators and between the public, the Senate, and the court.
What would you like 9 years? Because nine as well as 18 actually could work.
Nope.
The way it fits with 9 justices.
No, I think it's good that they serve for a
I
long
tried.
time.
Okay, you saw. Yeah. I tried to see if
He
we
did.
could. Okay.
But if I may, one last thing, I'm going on, but it's another reason why I'm very wary of the idea of the Chief Justiceship rotating. I think it's good for one justice on the court to occupy that role for a long time. Chief Justices, they tend to internalize an institutional view more than anyone else on the court, more than anybody else in government. The Chief Justice embodies James Madison's wisdom that the interests of the man must be attached to the rights of the place. Nobody embodies that more than a Chief Justice under our current arrangement. And frankly, I think if they rotated through as Chief Justices, none of them would really embody that in the same way. That's a little off topic.
No. This is one of the bigger changes, is the rotating Chief Justiceship. It's, frankly, the only constitutional objection, I think, that has any weight, because I'm actually changing it from a fixed office to a rotating thing. On the one hand, though, everyone's going to be chief, so maybe it diffuses it, but now everyone thinks about, chief, and this is going to be me one day, and gee, maybe I shouldn't be nice to this chief because that's going to be me one day, and it's hard. And it works pretty well at the Courts of Appeals. The Courts of Appeals, the chief judge of Courts of Appeals is basically rotatingly the senior judge on the circuit.
Or maybe they would drive the court like a rented car. They wouldn't have the same long-term institutional attachment.
But I can tell you it works very well at apex courts in other countries. That's how a lot of other countries do it, and most circuits.
That's true.
All right, we're going to pivot to audience questions. I'm very excited for that. Let's start here in the front.
Yeah, so
There's a microphone coming.
So I know that one of the proposed reasons for the plan is to ensure that retirements don't become political, right? Like at the nominal, the justice doesn't retire because he knows a specific president will be appointing. Yeah. Let's say it's getting to year 17 or year 15 to my term, and it's or year 14. It's an election year. It's a year for another judge. Would I still be able to retire as a justice and have that president appoint a new justice, i.e., like? Or the 18 terms?
In my plan, you do get to retire early. Maybe you need to do so for health or family reasons. Even today, you don't have to serve for life. I once was talking to Frank Easterbrook, I think, about what his plan was, and he was telling me he was going to retire at a certain point. I said, really? He says, Akhil, it's life tenure. It's not a life sentence. So you can retire early, but just like the Senate, you see, we're only going to fill the rump of your remaining 18 years. So you're not better off in any way than if you had served. At best, you clone yourself, but only for the remainder of you're allotted 18 years. So you're no better off. So you're not going to get strategic retirements at year 14 so that your replacement gets another 18. No, that person would only get the remainder of year 4. Just like it is for the Senate right now. If you leave the Senate early, someone fills your spot for the rump of your 6-year term.
Yeah, and so a follow-up, but then wouldn't you have the advantage of maybe having 2 18-year plus, like if you retire, you're still treated kind of like as an emeritus judge or whatever, a non-active justice. So could you have 3 or 4 non-active justices if you retire?
That's a really good point. And one thing that Adam didn't like is knowing who was going to be on deck or the pinch hitter for short side. Now, if you didn't like that, you could actually create a system in which that was going to be random, and you didn't know, which one of the seniors would actually, pinch hit either in general or could be case by case. Those things are all negotiable in the plan.
And it would be great TV. Can you imagine the curtains open and aha, it's Justice Thomas.
Like the NBA lottery or something. Who's going to get the first pick?
Yeah.
Yes.
And just to reiterate, those issues, in my opinion, are the greatest merits of Akhil's proposals here, and his approach would solve for that problem. But one more thing, just to repeat myself, what I was struck by more than anything on my time on the Court Commission was this sort of baseline assumption among my colleagues, among the people who testified before us, among other people in the public, that it's somehow unfair for one justice to get, one president to appoint more justices than other justices, right? Carter didn't get to appoint any in 4 years. Trump gets to appoint 3. Mm-hmm. There seems to be this attitude that what's fair is a president getting an equal number of appointments per term, totally divorced from what the state of the Senate is at a given moment in time. I think that we need to get the court detached from presidential politics and rooted more in constitutional politics more broadly.
And even though each president gets 2 nominations in Amar's world, unlike Ro Khanna's,
right,
there is no guarantee that the Senate's going to go for that. And how far you're going to have to actually move away from your preferred candidate in order to get someone through the Senate is going to depend on the composition of the Senate.
Yeah, it's interesting. Oh, sorry.
We should go to a few more.
Just one line. Akhil is focused on regularly scheduled vacancies. Almost everybody else is worried about regularly scheduled appointments, and there's a huge difference between those things, why I like his approach much more.
Yeah, thank you.
Further questions? Why don't we go again?
Sorry for going on so long.
Great, thank you for your time. So with the idea of pinch hitting,
Mm-hmm.
If we are rotating through every 18 years
Mm-hmm.
and they're in a retired semi-role,
Mm-hmm.
and now they're younger when they are retired.
Yes.
What's to keep them from becoming active celebrities that maybe now do run for the presidency?
That was where I think Adam made a very good point, and I said I would have any service that you want to do other than senior justice would be evaluated by the Judicial Ethics Committee, which could be the committee of current the active justices or active and senior justices, and they would actually issue, and it could be non-binding, an advisory opinion on whether this is consistent with proper ethics. And they could say, we don't want people running for the presidency or running for the Senate after this, not because that's wrong in and of itself, but because we think that if we allow that, that's going to bleed backward and influence their judicial decision-making. They're going to be running, in effect, for president in the last years on the court, and we don't want that. And so, and in your confirmation hearings, you'd probably have, as a practical matter, need to promise, and I don't think this is an improper promise, that you would abide by the ruling of the Judicial Ethics Committee about your post-court service. Now, here's what is unethical. If confirmed, I promise to uphold Roe versus Wade or to reverse Roe versus Wade. You can't make a promise about how you're going to rule on a case. That's really different, though, than making promises like, I promise I will be ethical. I promise I won't take a bribe. I promise I'll follow the Constitution. And I promise I'll abide by the rulings of the Judicial Ethics Board would probably be on the permissible side of promise giving.
Even if the justices could be prohibited through this approach from going into like private employment,
Yeah.
law firms, mediation firms, and so
Yes.
on. They'd be able to make immense amounts of money doing other things. They already make immense amounts of money writing books. Imagine a justice with more time on his hands, writing even more books.
And I would want all of those to be processed by an ethics committee, even your book deals.
Yeah. And the same with, they could go to teach at a law school and get paid an enormous amount of money.
And right now there are rules on how much you can get paid. It's I think either $10 or $1,000 a year while you're an active justice. Only certain there actually are ethical rules about different sources of outside income.
Yeah, I'm just so wary of the justices suddenly thinking more about what they might do. Remember when Judge Ludig, a great judge on the Fourth Circuit, left the Seventh Circuit, became general counsel of Boeing, and made an immense amount of money. He's a great judge, and he's been a great statesman since then. But a number of judges left the bench not long after that. And I just, again, my conservative instinct is against change here, because we've never seen anything quite like this. And I'm less confident that an ethics board could really police this well.
And it's an issue on lower federal courts. And I'll tell you who drives the issue. Since I talk to these guys all the time, it's the spouses.
Yeah.
And the spouses are basically saying you're being a chump. You know, you're not going to be on the Supreme Court now. Your moment has passed, and you got kids. And here are the baselines. You're being paid less than the lawyers who argue before you, and you're being paid less than your law clerks for 2 years from now, and you're being paid less than you could get paid in private practice, and your law school classmates, and these worthless professors who do nothing, and that's what the spouses say.
So you can regulate spouses.
Let's get a few more. Let's go right over here.
This one's for Mr. White. For those,
Is the microphone on? Okay, good. Okay.
so for those who didn't have the chance to take your seminar, could you explain how Republican virtue is a solution in lieu of term limits, and how you articulated that in your time at the commission?
Oh, I don't know that it's a solution. The basic central sort of core of my work these days is trying to focus on the founders' thought on Republican virtue as the indispensable complement to everything they knew about structure in government. And that while we have a system built for men who aren't angels, and where ambition counteracts ambition, the founders, especially Madison and especially Hamilton and Washington and others, they understood that our system depended on self-restraint as much as it does on ambition counteracting ambition. And so at the end of the day, I see that as the essential challenge on the judicial retirement issue. I think as a matter of judicial statesmanship, as a matter of judicial appreciation of the constitutional good, they need to stop these timed retirements. And again, I wish that I saw an easy solution where we could legislate this away, but I will persist, even my friend's good arguments notwithstanding, that the medicine would be worse than the illness here. And that at the end of the day, the only real solution is going to be a sustained appeal to the judge's own better angels.
Just by way of reminder, Salmon P. Chase is Chief Justice who's running for president. And William O. Douglas is angling to get Franklin Roosevelt to name him his vice presidential running mate in 1944, in which case he would have been president several months after the inauguration when FDR died. And Jay leaves to be governor of New York, and Cushing is running for the governorship of Massachusetts. He loses. Hughes leaves the court to run for president. This is a problem even in our existing system, truth be told.
Mm-hmm.
So we can probably fit one last question in. Let's go over there.
This is a question for is this on? Okay. This is a question for Professor Amar. We've already seen in terms of like U.S. legislative elections that they keep getting longer and longer and more caught up. Why does just holding these judicial nominations in off years prevent that? Would it simply increase the length of the election cycle and sort of fold this process into it and make it a much more regular partisan battle?
You're right. We're living in an era of perpetual campaign. The New York Post actually had a piece this morning saying, Florida man makes an announcement. And it was apparently about some retiree golfer down in Florida who only hours after the last election, and before even the House has been determined, apparently said he's running for president. It's a hoot of a piece. Read it. It's in the New York Post. They're totally trolling Trump, but you're living in a world of perpetual campaign. Still, most political scientists would say, like the great David Mayhew, who is preeminent on Congress, and if he comes out of retirement, he's a senior, he's emeritus, to teach a seminar, you have to take David Mayhew for Congress. I think most scholars of Congress would say you can get more things done in years 1 and 3 than you can get done in 2 and 4 in eras of divided government. Unified government might be very different. So even today, we still say it's perpetual campaigning, but 1 and 3 are less supercharged than 2 and 4.
But it would be interesting to see how it would affect the off-year Senate elections, I guess. And going against my worry that this system would entrench it as a matter of presidential politics, the Senate elections leading up to the nomination cycle would become even more about, maybe exclusively about the Supreme Court.
We already are in a world, and I don't think we can go back, where presidents are in effect telling you about the court. Trump says, I'm going to pick off a certain list in 2016. So already when you're voting for a president, you're actually, increasingly today voting. Now, he didn't say it's going to be Bork. Bork is dead, of course, but or it's going to be Barrett or Kavanaugh or Gorsuch. But he did say, I'm going to pick off this list, and he did, to his credit, pick off that list. And I'm glad he picked off that list, because left to his own devices, he would have picked Judge Judy, or Sidney Powell, John Eastland. I mean, so I'm glad he picked off a sane and sober list, rather than picking from his own.
Not Adrian Vermeule.
Group of his cohort of kind of cronies and crackpots, and so. But we're already moving in that world where the judges are being swept into the presidential election system, and we're continuously in a world of presidential and senatorial election. That's true. That's where we are today.
I'm against that tide of history, and I would like to stand athwart it, yelling stop.
And so stop. That's a reference, of course, to the opening issue of the National Review, co-founded by a fellow named Buckley. You might have heard of him, saying what conservatives believe and what the National Review is all about. Standing, in the stream of history, athwart the stream of history, and yelling stop.
That's right.
Yeah.
So now we'll pivot into closing remarks. We can start with you, Professor Amar, 2 minutes.
I didn't know I was going to make a close. So listen, I think you've heard, a very thoughtful person, my friend Adam, suggesting that there are reasons just to not change, to stand athwart history and just say, stop, let's just not make any change at all. And if you think our current system is working very well, I do think just a very good argument is a traditional Burkean idea that the burden of proof should be on someone who's proposing a change. My claim is, even if you don't adopt my approach, we're already changing the system in all sorts of ways, like justices being pulled into the presidential election cycle, with presidential nominees telling you who they're going to put on the court. This last election, an off-year election, was an election on the court, very much framed by Dobbs. So we're already there, and the question is, what's the best way to move forward? My own thought is, for those 18 reasons, the best way is to increase judicial humility. So now they're not going to be there for 35 years, but only for 18. Lower the stakes, lower the temperature by having it in years 1 and 3, and again, only for 18 years and not for 35. If he said he'd go for 9 rather than 18, I say, that's interesting. We could talk about that.
Not quite what I meant.
I know. But if he did, but 9 and 18 have certain special mathematical principles. And here's what they do finally that might appeal to conservatives like you. They cement in place a 9-year idea or an 18-year idea, a 9-person court. Okay, and right now there are crazies out there. There are more in my party than I'm a Democrat who want to pack the court. My system is ingeniously designed to actually make that harder for them to do, because I think that's a bad idea. The thing will spiral out of control. Mine is adopted behind the veil of ignorance. If you agree with it, it could go into effect 4 years from now or 8 years from now. It's not about changing the existing composition for narrow, immediate partisan advantage. Steve Calabresi and I proposed it back in 2002. I still think it's so. And the rules are clear going forward. We're not going to be pushing off existing justices. This is not about throwing Clarence from the train. Okay, that's not what. It's going forward. Every person who is confirmed by the court knows that he or she will have 18 years of regular service followed by, a lifetime thereafter of senior service.
And I'd just say briefly, Akhil said that his proposal is neither left nor right, and neither blue nor red, and that's true. And I think that speaks very highly of it. But it is among almost all of its advocates, it is presidentialist. It comes primarily from those who want to see the court more aligned with the presidential political calendar, not less. And again, I think that's the core fault of it. And then my very last point is, this would certainly change things about our politics, the politics around the court. This proposal, like the court packing proposals and others that I've seen, they wouldn't actually, I think, improve the court's functioning as a court. I don't think it would actually make the court better at doing its constitutional job of hearing and deciding cases. There are things that could be done to improve that, how the court selects its cases, the discretion it has, how the court grants injunctive relief, has a lot of discretion there that might be changed. But this is an area where I think we're changing the court due to things outside of the court. And I would rather keep the rest of the world at bay and just protect the court as it is.
And with that, why don't we give our two wonderful guests a round of applause.
It was a lot of fun. A lot of fun.
Thank them for a wonderful debate.
That was a lot of fun.